In the previous video, we covered how in 1933, the House Joint Resolution number 192 placed us under equity jurisdiction where individuals have no rights. Today we're going to continue to discuss the effects of that resolution and move into the fractional reserve banking system as well. The states and individuals, thanks to this House Joint Resolution, have been compelled to perform services in order not to pay because no one could pay anymore. There was no money with which to pay, but to discharge obligations to pay. What's called the fractional reserve banking with irredeemable paper creates multiple demands upon a common substance. So, with multiple demands, no one can ever satisfy all his claims, and no one can ever pay at law in substance, that is, with standard gold dollars, but instead can only perform services as evidence of his willingness to discharge the obligation to pay. Payment, as such, is thus forever postponed. One only promises the payment. So overnight, the entire country was placed in an entirely new regime of equity, which never pays a thing but only compels services forever to the private banks. And the debts to private bankers constantly increases. The interest obligations, known as debt service, constantly compounds, and the performance of services in order to discharge the obligation to pay this interest are never ending, being a greater and greater burden upon ourselves and our children and our children's children. In other words, a feudalistic real property law in the guise of equitable discharge of obligations to tender in equity and not pay at law was instituted in violation of our allodial property rights and compels individuals into a feudalistic peonage or involuntary servitude to the private banks, the Federal Reserve banks, national banks, state banks. This is in violation of the 13th Amendment to the Constitution for the United States of America. Because of the jurisdiction of the law merchant, we're not under common law. We do not have access to our right to a common law jury, and as a result, our property can be, and every day is, taken without due process of law. If we do not perform the services, our property is taken from us by equity courts imposing the law merchant. The banks, including the Federal Reserve banks and the national banks, are incorporated by the state and operate under banking statutes, not laws, which allow or at least do not prohibit the creation of demand deposits or checkbook money, which is not really money, but is actually credit or debit created on the spot out of thin air on two levels. One, by the Federal Reserve banks. They write checks on themselves, thereby creating Federal Reserve credit out of thin air in order to purchase investments, such as U.S. government securities, which then become part of the national debt and provide banking system with new reserves. On the strength of these newly purchased securities, they're able to obtain from the Treasury newly printed Federal Reserve notes to cover the new checks when they're cashed, and they only have to tender about 2 cents for each new Federal Reserve note. They're practically given the new paper notes, and they still hold the bonds, which are part of the national debt, and collect interest on them. The second level is by the local commercial bank, which creates bank credit, denominated demand deposits every time they make a loan. The Federal Reserve, a private Anglo-German American-owned corporation, creates public credit or national debt, while the commercial banks create private credit or private debt when they make a loan. The Federal Reserve note, at least the one issued in accordance with Title 12, United States Code Section 411, which requires that they shall be obligations of the United States and shall be redeemable on demand, has a double jurisdiction. It's what you may call a legal tender for an equitable interest. That means it passes at law as money, being a legal tender, but the only interest it passes along is a mere demand or promise. Hence, though it is legal or at law, it never pays the gold because of House Joint Resolution number 192, which illegally and criminally prohibited payment of the U.S. standard dollar lawful money at par and thus at law. It should be noted that Congress could not take away our rights to use banknotes at law or demand deposits at law. They just took away our money. We have a right to take a $20 bill, which means a bill for $20, into a bank and demand a $20 gold piece. Congress didn't take that right away. Since we have unalienable rights which cannot be taken from us or be forced to give them up, Congress just took away the gold. This was and is a criminal usurpation of the sovereignty of the people on the part of Congress and various states by allowing it to happen at the time and by continuing to allow it to happen to this date have become party to this crime against the people. Instead of going into bankruptcy, everyone, including the states, was provided with the opportunity to use the new Federal Reserve notes, called incorrectly lawful money, grounded in perpetual debt of the eligible paper, which formed the assets of the Federal Reserve and the national banks. These are also known as units of monetized debt. Everyone, thus, became the creditor-debtor of everyone else, since no one has paid or been paid for anything since June 5th, 1933, and thus, overnight, became liable for specific performance on the basis of a debt action of assumpsit, which we talked about in an earlier video. The debt action of assumpsit is under the private law merchant, operating outside of the Constitution and imposing an equitable jurisdiction, one in which no one has any rights, where one can be compelled summarily to deliver his property without trial by common law jury, and the debts to the private bankers keep mounting ever higher. A free-born sovereign individual can't be forced into perpetual debtorship and involuntary servitude, that is, feudalistic performance on behalf of and for the benefit of any person, real or juristic, against his 13th article of amendments to the Constitution for the United States of America, and cannot be compelled by law to accept or to give informed consent to accept an equitable jurisdiction foreign to his Bill of Rights. Article 3, Section 2 of the Constitution for the United States of America states in part, "The judicial power shall extend to all cases of admiralty and maritime jurisdiction." At the very beginning of government under the Constitution, Congress conferred on the federal district courts exclusive cognizance of all civil cases of admiralty and maritime jurisdiction, saving to suitors in all cases the right of a common law remedy, where the common law is competent to give it. As this jurisdiction is held to be exclusive, The power of legislation on the same subject must necessarily be in the national legislature and not in the state legislatures. Congress enacted the Limited Liability Act on March 3, 1851. It's codified at Title 46 United States Code, Sections 181 through 189, as amended in 1875, 1877, 1935, and 1936, and the Act of 1884. It intended to cover the entire subject of limitations and to invest the U.S. District Courts with exclusive original cognizance of all cases of admiralty and maritime jurisdiction, exclusive of the states. This means that the states don't have any jurisdiction in admiralty and maritime matters at all. Admiralty and maritime jurisdiction comprises two types of cases. First, those involving acts committed on the high seas or other navigable waters, and two, those involving contracts and transactions connected with shipping employed on the seas or navigable waters. In other words, the second type of case must have a direct connection with maritime commerce. Suits in admiralty traditionally took the form of a proceeding in rem against the vessel, and with exceptions to be noted, such proceedings in rem are confined exclusively to federal admiralty courts. Because the grant of exclusive jurisdiction to the federal courts by the Judiciary Act of 1789 has been interpreted as referring to the traditional admiralty action, the in rem action, which was unknown to the common law. State courts are forbidden by the Constitution to have admiralty jurisdiction, while state courts are permitted to handle and try admiralty cases if the suitor desires. It must be an admiralty matter to begin with, and it must involve property. Otherwise, there would not be a common law remedy. In other words, the common law courts would not be competent to handle it. More than this, it would need to be tried in a common law court following common law procedures, not equity procedures, with a trial by a common law jury. Therefore, any attempt by a state court to impose a judgment in rem is in violation of the Constitution and is null and void. When a sheriff attempts to enforce a judgment in rem, he's attempting to impose an alien and unlawful Roman civil law in violation of his oath of office, and he's thereby committing a criminal act. The American people are beginning to catch on to and realize the nature of the dictatorship of unelected rulers that's been set up in this country, and it doesn't look like they're going to stand for it much longer. As the issues become clarified, each public official will need to make a decision. Shall he be on the side of the Constitution and protect the rights and freedoms of the people as required by his oath of office, or shall he be a party to the criminal usurpation of the sovereignty of the people? The sheriff is a key person in all of this. He can either be a tool of the forces who've set this up and provide the oppressive force that binds the innocent victims to the chains of slavery, all in the name of doing his duty, or he can be an instrument of the liberation of the people by preventing the imposition of the unconstitutional equitable jurisdiction, the Roman civil law, upon the victims and their property, and protecting their rights and their freedoms. So, folks, this concludes Chapter 1 of the History of American Constitutional or Common Law. In the next chapter, we're going to cover the Commerce Clause. So, thanks for subscribing and watching, and I'll see you next time.